Hi everyone, welcome back to Jurisprudence by Jen. This is week number 7 and we are going to be discussing factor number 7. The factor number 7 of Pennsylvania child custody is the well-reasoned preference of the child based on the child's maturity and judgment. For those of you who do not know, I am Jennifer and I am the attorney here in the Commonwealth of Pennsylvania. I own a law firm called JD Law where I focus my practice in the areas of family law and general civil law. This is the 6th video in this series where we are currently looking at Pennsylvania child custody and the 16 factors a judge considers when evaluating a child custody case. So if you missed all the other videos, go back and check them out. As always, I have to put my disclaimer in here that says that I'm not able to provide specific legal advice in these videos, but I am able to go over general information that is out there that you'd be able to Google. If you do have a legal question or concern, or if you need more information regarding your individual case and what's going on with you, please contact me by phone at 412-295-8066 or email at jennifer@jdlawpa.com, and we can go over those specifics. Just so you are aware, this is March 29th, 2018, and I will be out of the country from April 7th through the 16th. So if you need anything at that time, still email me. I am going to be available via email. I just may not be able to meet in person right away, but we can definitely get you scheduled, get you in, and we can talk to you as soon as I get back. So the preference of the child. I have heard this 100 times over and over. Every client asks it or says it. Just let my child speak to the judge. The child will tell the judge how she feels about going with her father. Or my son definitely doesn't want to go see dad anymore and tells me all the time he only wants to be with me. I will be very honest right up front. The likelihood of a judge speaking with your child is, well, it's not really likely at all anymore, really. The court system tries as hard as possible to keep children out of custody battles. These are battles between two adults, and pitting the child against one another is not a productive solution. So whether a child can testify will be determined on a case-by-case basis, and while it is granted in specific circumstances, it is done so very seldomly. If a judge does choose to speak with a child, they're going to check two things first. 1, the maturity of the child, and 2, the judgment of the child. The younger the child, the less likely they are mature enough to make a sound decision on who they want to live with. A younger child may not fully understand or comprehend what the court proceedings are and what they actually mean. A younger child also may not understand the difference between a truth and a lie, even if it isn't an actual lie, but more likely what they are experiencing in their reality. So a judge is going to look at all of this first before we move on to the next step of what is the child's judgment and what is their judgment based on. When it comes to judgment, a younger child may not have sound reasoning when it comes to their preference. A younger child may want to live with mom this week because dad won't let the child go to a friend's birthday party, or the dad may have taken away the child's favorite toy. Next week, the child may be mad at mom and want to go live with dad because mom made the child do their homework before watching TV. Their judgment on this basis is unreliable at this level of maturity. So we're talking generally kids younger than 10. In this situation, their testimony will not be considered with much, if any, weight by the judge. The judge is going to look at the other 15 factors before they consider whether the child has a sound, reasonable preference. While an older child may be permitted to testify because they have met these two previous requirements of maturity and judgment, the judge still may not allow the child to testify in court in order to ensure that they are not put in the middle of their parents' dispute. An older child will be more likely to be mature and to understand the proceedings that are happening around them. An older child is also more likely to understand the ramifications of what they tell the judge, and the fact that if they tell the judge which parent they want to live with, it may result in that scenario. An older child will likely have a more thorough and thought out opinion of why they want to live with one parent versus another. Maybe one parent is manipulative. Maybe one parent has a very mean spouse. Maybe one parent doesn't support extracurricular activities that the child actually participates in. All of these are well-reasoned, thought-out reasons to prefer one parent over another, and a judge may be likely to consider them if the judge actually gives the child the opportunity. And so a lot of times you see the child's preference being brought in under other witnesses and through other examples and exhibits rather than the child actually testifying. So that is it for Jurisprudence by Jen. Thank you for tuning in as always. We will be back next week where we will address factor number 8. If you have any questions in the meantime, hop on over to our webpage at jdlawpa.com and send us an inquiry. Just a reminder, if you need specific legal advice associated with your case, you can call me directly at 412-295-8066. Thanks, and we'll see you next week.